Okay, as a footnote, AIA received a warning from the PDPC. No fine, just a warning, but it included an undertaking that they will review all the processes and make sure this doesn't happen again. Okay, so there's no real danger if you don't really comply, but let's just say that if you're the second or third one to be caught in this situation, I'm not sure whether the PDPC will be so lenient now. Okay? Okay. This one is to do with the protection obligation. Now you have a database in your, shall we say, possession, custody or control. I'm sure all of you follow the news. Almost every week or every other week, there is a report on some data security breach happening. Whether you are hotel industry, medical industry, banking, I think get hit the most nowadays. If you use Swift, you know what I'm talking about. Okay, later I'll tell you a very nice tale. So, the Act says you must have reasonable security arrangements. So what is reasonable? Okay, the good thing is no one knows. It's constantly being updated. It's constantly being changed, right? You constantly have to be on your toes because the bad guys, okay, I just call them the bad guys, are always finding new ways to, shall we say, penetrate into your system. Okay, so I just given some ideas here. Keep in mind the second point, practice guidelines from regulators. Okay. There's actually two cases that I want to mention. I just put this up first. The other case is a little bit more exciting. Target case, I mentioned this just to illustrate the cost of a breach. You all know what happened to Target 2013. Target is a very big department store in the States. So 2013, 110 million accounts were hit. Okay. At last count, the cost to them in terms of payout in compensation to all the different parties, 290 million. Okay, and this is ongoing. Now, this is only for matters already concluded or settled. There are others like claims from customers, shareholders, investigation from regulators, and the damage to the reputation. All this is still ongoing. Okay, so you can imagine this is just the tip of the iceberg for them. Now, what they tried to do in respect of their customers was, the customers actually bought a class action lawsuit in the States, but they tried to stop it. They say this is not, they wanted to throw the case. It didn't work, okay? And I think those of you who have calculator, better take out, okay? It's quite a long story. This is just a list of things they were supposed to do. Okay, they had to pay for credit card losses. They had to encrypt all customer data. They had to comply with local federal law regarding data security and retention of data. They had to adopt EMV chip technology for their credit cards. They had to provide extended credit monitoring services. They had to answer for breach of consumer protection laws. They had to answer for failing to timely notify customers of the existence of the breach. By the way, between the date of the breach occurring and the date of the discovery was 7 months. Okay? And of course, negligence for pure economic loss. Now, usually for this kind of thing, the monetary part is not the most important. The most painful part is, of course, the undertaking to comply with the regulators' requirements. The regulator will usually say, okay, you need to take remedial action in addition to the restitutionary measures. Okay. The other one which I didn't put up, the other case which I want to talk about is the Central Bank of Bangladesh. I don't know if you all heard about that. It's a cross between, if you haven't heard the story, it's a cross between Ocean's 11, James Bond, and Italian Job. Okay, if you all like movies, you know what I mean. Okay, suffice to say, all this started with SWIFT. Okay, so hackers went into the system of the central bank, I call them BCB for short, managed to, get their SWIFT code, send instructions to the Federal Reserve Bank of New York, instructed them to wire 101 million US to a bank in the Philippines. Okay, I think the name is Rizal Bank. Now, from there, 81 million went to the Rizal Bank, 20 million went to Sri Lanka. The 20 million that went to Sri Lanka was eventually recovered. The 81 million from that went to the Rizal Bank was further distributed to 5 casinos in Manila. The money is still gone. So after that, there was a lot of finger pointing amongst everyone. The Bangladesh police blamed SWIFT. They also blamed the Federal Reserve Bank of New York. The SWIFT people blamed the BCB for having a outdated system. All right. I think all this happened in February, March, or the story broke in February, March. In June, they had the settlement talks. I don't know what happened. They didn't want to reveal them. There's a part 2 to this. Forensics experts, BAE Systems, they actually published a report to say that hidden in the code of they found some code, and hidden in the code were names of 7 other banks that were potentially targets. They also named the Hai Phong Bank in Vietnam as another victim. And they said that the 7 banks that were named, 6 are from Asia, 1 is in, I think, Europe. Okay, now of course, needless to say, all this prompted a lot of questions and everybody denies. No comment, don't know what happened, but we have nothing to say. Now there's a part 3 to this. We also later learned that there's this Ecuadorian bank that started legal proceedings in New York against the what do you call it? I can't remember the American bank's name, but they sued them in New York again because of wrongful carrying out of SWIFT-related instructions. This one, I think, was to the tune of, I think, $20 million. Okay? So anyway, this whole story, there's a lot of things involved, but the bottom line is that the obligation to protect is very real. Okay. Now, I just give some examples of what we have found. Needless to say, almost every month, regulators are coming up with, different regulators are coming up with new standards or guidelines or best practices. Okay, we found this in 2014. The US NIST issued a new cybersecurity framework, how to have best practices. I believe this year they are updating it. Now, in addition to them, I will also say this. Now, in the past year and a half, the New York Stock Exchange, the Hong Kong Monetary Authority, our MAS is not. MAS is 2013. And even the US FDA, the ones responsible for is like their equivalent of our HSA. All of these regulators have issued guidelines, best practices, and directives how to ensure cybersecurity protection. Recommendations, guidelines, initiatives, you know. And one more thing which is coming, I mean, excuse the Malay, you all understand Malay, right? So you excuse the Malay, this is coming soon, okay? Breach notification. Now you think about it, if you have a database that has been breached, right? Are you obliged to notify anyone? Currently, under Singapore law, there isn't, okay? But there is a guideline issued by PDPC last year. They recommend that you tell them first, okay? And of course, if you have followed the news, you will see that there has been an announcement in the press that come early next year, I'm not sure, February or May, there's a new Cybersecurity Act coming into force. And one of the things that they will introduce is an obligation to notify, don't know who yet, but there's an obligation to notify in the event of a breach occurring. Okay, by way of comparison, just to let you know, in Europe, for the equivalent provision, the obligation is to notify, I believe, within 24 hours. Okay, so you just bear this in mind. This is coming soon. Now, I just thought I'd add this for effect, the international element, because besides our PDPA, there are lots of other countries which have, shall we say, equivalent obligations. Now, DP laws throughout Asia, as a stock check, Singapore, Philippines, Malaysia, South Korea, and Taiwan, they all have fully fledged omnibus data protection laws. So all those three things which I mentioned, the protection obligation, transfer limitation, and the purpose limitation, all of these countries will have equivalent or even worse, more stringent obligations. Okay? Vietnam and Indonesia, last check, they don't have omnibus PD laws, but they have sectorial or regulations. So depending on which sector you operate, you might be obliged to follow. Thailand, we understand currently there's no regulatory requirement, but it is, if I use a common phrase, akan datang. Okay, but they're talking about it for years, so I don't know when it's going to come on board. Okay, for those of you who follow European news other than Brexit, there is this 2 or 3 new developments under that which you might want to take note of. The GDPR, the General Data Protection Regulation, effective 25th May 2018. The reason I mention this is because of the extraterritorial effect. What they want to do is this. They want to make it binding on non-European businesses who offer goods or services to individuals in the EU or who monitor their behavior in the EU. Okay, now how they're going to enforce this, I'm not sure. But that's what the law says. And of course, the Privacy Shield just got approved yesterday. This is between the States and Europe. I only mention this because it covers transfer of data internationally, and it affects American and European companies. Now, we actually have one equivalent, or no, I won't say equivalent, we actually have one which is potentially applicable for Asia. Okay, unfortunately, it doesn't have a very popular take-up. No one wants to do it. I think at the moment, there are only 14 companies who have agreed to adopt it, the CBPR, Cross-Border Privacy Rules. That's APEC level, you see. But again, this one, I don't mention it because it's not very popular. Okay. Now, with that, okay, this is a little bit about us. Okay, don't need to all this. And I say thank you very much. You've been a very captive audience. Now,